Hello, my name is Dan Shabetta Jr., and I'm giving a presentation lasting 1 hour for attorneys newly admitted in New Jersey, civil trial preparation basics. This is a presentation for people who are already admitted in federal court or in their home state, and I'm going to be going into things about New Jersey that are distinctive. I have a unique perspective on this. When I had been a lawyer for about 7 years, we had a client who brought us some New Jersey cases, and so I had to get myself admitted in New Jersey. And so I took the bar review course, and I took the bar exam, and I passed it. But as you know, when you take the bar exam and study for it in a different state, a lot of these facts just swim in front of your eyes, and you really have to practice to really know how the game is played. And I made some mistakes by being surprised about New Jersey practice in some respects. Fortunately, nothing that was not fixable. Anyway, this presentation is geared to people like me who have already been practicing in other places, and it's about things in New Jersey that would surprise you. All of this has to do with civil trial preparation. Now, I must say that in New Jersey, civil trial preparation is basically the same as it is everywhere. You have to keep track of your witnesses, make sure they're ready, prep them, make sure all the necessary records are subpoenaed into court, speak to the associate who has been living with the case for a year or two, who knows the case, be aware of what motions have been made, what orders have been made, what the law of the case is, etc. I'm going to go into things that are distinctive about New Jersey. The first part of the presentation will be about the procedural differences. Then I will go into differences in substantive law to the extent they are different from elsewhere. And finally, I'm going to give a short presentation on the impact of electronically stored information, which everyone has to know about these days if you are concerned about trial preparation. New Jersey has the usual liberal pleading rules. You might remember in law school the Diaguardi case in 1941, where a very crudely written complaint passed muster. It's called notice pleading. However, you cannot go on and on with endless boilerplate and not mention facts like you can in some jurisdictions like New York. Every pleading has to have a statement of facts. You'll see in your written materials on page 004, 452, a claim for relief shall contain a statement of the facts on which the claim is based, showing that the pleader is entitled to relief and a demand for judgment for the relief to which the pleader claims entitlement. And as elsewhere, you can make alternative theories that are contradictory, but you can do that in the pleading stage. You simply can't do that at trial. But before then, you can. One distinctive feature about New Jersey practice, as you know, in a workplace accident case, the employee cannot directly sue the employer because of the workers' compensation bar. However, in New York, you are allowed to sue the employer directly as a defendant for discovery purposes. There are no allegations made against the employer, but you can get early discovery from the employer, which is very handy because instead of waiting for him to be joined as a third-party defendant sometime down the road, the employer often knows a lot about the facts of the case, and you could depose the people on the site, the employees, get discovery from the employer as to documentation of the accident and the necessary contracts, etc., and you can do that right away. Again, there's no allegations, and once you get the discovery, you're supposed to immediately dismiss them from the case. The leading case on that is Davila versus Continental Casualty. It is in your written materials on page 007, etc. Another distinctive thing about New Jersey practice is that when you bring a lawsuit, you have to fill out a civil case information statement, and that is on page 009. There are 3 tracks for discovery in New Jersey law for most cases. There are some exceptions, but there's track 1, which has cases such as forfeiture, tenancy, real property, PIP coverage, uninsured mortgage coverage. Those are track 1. They have 150-day discovery deadline. running from the date that the answer is served. Track 2, construction accident cases, employment cases, personal injury, other kinds of torts, that's 300 days. Track 3 is 450 days. That's civil rights cases, assault and battery, medical malpractice, product liability, etc. These are listed on the second page of the civil case information statement. And the way New Jersey works is you have those deadlines, and that's it. That's the end of discovery. It's automatically ready for trial. You don't serve a special notice of trial or notice of issue as you do in other places. You can ask for extensions, and they are routinely granted, but you do have to ask for them and have some kind of a reason why the extension is necessary. Document discovery is similar to other states.